In this video, we're going to be looking at constructive dismissal. So, what is constructive dismissal? In employment law, we see constructive dismissal as a situation where the employee resigns from their employer's place of work because of something or some things that the employer has done that causes a breakdown in the mutual trust and confidence between the employee and the employer, to the effect that the employee feels that he or she has no choice but to resign. Now, there are a number of prerequisites in order to be eligible to bring a constructive dismissal claim, and a couple of those are these. One, you need to have at least, at the moment, at least as far as 2020 present is concerned, 2 years of continuous employment service. So 2 years having been with your employer in order to bring a constructive dismissal claim. If you haven't got that, then you bring something else called a wrongful dismissal claim, but we don't talk about that in this particular video. The second thing that you need to make sure that you do in order to be eligible to bring such a claim is that you need to have brought that claim within 3 months minus a day of your resignation, and certainly from the date of the last act. So those are a couple of things to think about with respect to what exactly is constructive dismissal. Now, how exactly do you win a claim, and or what does that look like? Well, the reason for your constructive dismissal needs to be significant enough so as to have actually breached the contract, the employment contract between you and the employer. So that can be things like bullying, or the employer not following a due process with respect to you bringing a grievance, or perhaps them bringing a disciplinary. It could be a sudden demotion or unlawful deduction of wages. And it can also be mixed in with discrimination too. So those are some things that are examples of grounds for bringing an unfair dismissal claim. So how is compensation broken down? Compensation is broken down at the moment in 2 ways. One, you have something called a basic award, and that typically is a statutory calculation. It's similar to that for redundancy, but that statutory calculation will form part of your basic award. Then, same with that, concurrent with that, you have something called a compensatory award. And the compensatory award takes into account a number of things, for example, the severity of the conduct of the employer, and indeed the employee too. It also takes into account things like how long you've been out of work, for example. And in order to figure out what that figure looks like, the tribunal will typically have a look at some of these factors, come up with that particular sum, and that sum will be the lower of two things. At the moment, it's going to be the lower of either your salary, or indeed it will be up to £88,519. So those are some things for you to think about with respect to constructive dismissal. You are welcome to get in touch with me if you do indeed think you've got a claim, or you'd like some further information in terms of delving in deeper, or indeed even if you want some representation at a tribunal. I'm more than happy to help. The website details are below. That's magaralaw.co.uk, or indeed you can email me at roy@magaralaw.co.uk. Thank you.